Today, we're diving straight into a massive, high-stakes legal tug-of-war. We're talking about the intense dilemma employers face when deciding whether or not to look into a job applicant's criminal past. It is a huge issue, one that touches on public safety, civil rights, and literally millions of dollars in legal liability. Let's get into it.
All right, here's our roadmap for untangling this complex web. We'll start with the employer's Catch-22, look at the data on incarceration and racial disparities, explore the ban the box movement, dig into federal civil rights laws, examine the very real threat of negligent hiring, and finally, talk about finding a legal balance. We're going to systematically break down these conflicting pressures from every angle.
First up, the employer's Catch-22. We really have to start by outlining the ultimate paradox that businesses are facing right now. Think about it. Employers are legally mandated to provide a safe workplace for their staff and customers. But on the flip side, they can be heavily punished by the federal government if their safety screening disproportionately affects minority applicants. So you're essentially punished if you do and punished if you don't.
Moving to our second point, the data foundation regarding incarceration and racial disparities. Before we can truly grasp this legal mess, we have to look at the numbers. We need to understand the stark reality of mass incarceration in the United States, because this data is the absolute foundation of why this is considered a major civil rights issue.
These numbers are absolutely striking. We're looking at the lifetime risk of incarceration for men in the U.S. broken down by race. For white men, the risk is 1 in 17. For Hispanic men, it jumps to 1 in 6. And for Black men, it is a staggering 1 in 3. Because minority men face these drastically higher lifetime incarceration risks, any blanket policy that outright bans hiring ex-offenders is inherently going to have a disproportionate racial impact. When an employer broadly refuses to hire anyone with a record, they're inadvertently wiping out a massive segment of minority applicants. Now take those staggering disparities and combine them with this: 92%. That is the percentage of employers across the country who use criminal background checks for some or all of their job openings. When you put those two things together, you've got two massive statistics on a direct collision course. Millions of people are returning to society needing jobs, and nearly every single job out there is checking their past. Which brings us to Section 3, the ban the box movement. Let's pull the rope over to the applicant's side for a second. The law is actively trying to protect applicants, and a huge part of that is a grassroots initiative that has swept across states and municipalities, aiming to give ex-offenders a genuinely fair shot. This movement brilliantly illustrates how different jurisdictions are trying to break the revolving door of recidivism. Ban the box literally means getting rid of that little "have you ever been convicted of a crime" checkbox from initial job applications. Now, the goal here isn't to force companies to hire dangerous people. Rather, it just delays the background check until the interview stage or until a conditional offer is made. This gives applicants a chance to get their foot in the door, present their skills, and actually show evidence of their rehabilitation before being automatically disqualified by a piece of paper. It's been widely adopted by states like Rhode Island, Hawaii, Minnesota, and Massachusetts, plus major cities like Philadelphia and Seattle. Next up, Section 4, disparate impact and Title VII. You see, applicant protections aren't just local initiatives. They are powerfully enshrined in federal civil rights law under Title VII of the Civil Rights Act, which is strictly enforced by the Equal Employment Opportunity Commission, or the EEOC. Here's the crucial takeaway from Title VII. A hiring policy doesn't actually have to be intentionally racist to be totally illegal. This concept is called disparate impact. If a completely neutral-sounding background check policy unfairly screens out minorities without a strict, provable job-related necessity, it violates federal law. So even if an employer genuinely thinks they're applying a fair blanket rule to everyone, if the math shows it's knocking out minority candidates at a disproportionate rate, the government can and will step in. The EEOC draws a massive line in the sand here between arrests and actual convictions. They explicitly warn employers that rejecting someone just because they were arrested is incredibly risky. Why? Well, because an arrest doesn't equal guilt. We operate on innocent until proven guilty, and charges get dropped or dismissed all the time. Convictions, on the other hand, carry the highest degree of proof in our justice system. But, and this is a big but, even with a conviction, the EEOC says you can't just auto-reject a candidate for a decades-old crime if it has absolutely nothing to do with the job they are applying for today. And just to prove this isn't some abstract legal theory, take a look at these real-world EEOC enforcement actions against major corporations. A flawed background check policy can literally cost millions. Pepsi Beverages agreed to a $3.13 million settlement because their policy excluded hundreds of black applicants over minor offenses and mere arrests. Dollar General and BMW faced intense systemic race discrimination lawsuits because their broad screening formulas knocked out vastly more minority applicants than non-minority ones. So yeah, the stakes here are incredibly high. Which brings us to Section 5, the negligent hiring threat. Now we need to pull the rope back the other way. Let's look at the terrifying risks employers face if they don't screen their applicants. You have to realize, employers aren't just running these checks for fun or to be difficult. In many highly regulated industries like finance, maritime security, or childcare, state and federal laws explicitly demand that they conduct these checks and disqualify certain offenders. For instance, if you're hiring an EPA contractor at a sensitive site, a port worker, or a bank teller, federal statutes strictly prohibit you from hiring folks with specific criminal records. In these cases, compliance isn't optional. It is literally the law. But even if a specific statutory mandate doesn't apply to a business, there's this constant threat hanging over them, called the tort of negligent hiring. Basically, if a company skips the background check and they hire someone with a deep history of violent crime, and that employee ends up assaulting a customer or a coworker, the victims will absolutely sue the company for failing to provide a safe environment. It happens all the time. So let's pull all of this together. This right here is the ultimate catch-22 of our entire explainer. On one side, screen your applicants too broadly, and you risk a massive federal civil rights lawsuit from the EEOC for disparate impact. On the flip side, ignore their criminal histories completely, and you risk a devastating negligent hiring lawsuit from victims if workplace violence or theft occurs. Honestly, you don't have to take my word for it. Take it straight from an actual EEOC commissioner, Constance S. Barker. She captured this anxiety perfectly, saying, "All this new guidance does is to put business owners between a rock and a hard place. Conduct criminal background checks to protect your employees and the members of the public you serve, and you bear the risk of having to defend your actions as discriminatory. Don't conduct background checks, and you take the risk that an employee or a member of the public will be harmed." When even a member of the agency enforcing these rules points out the impossible tightrope businesses have to walk, you know the system is incredibly difficult to manage. Finally, Section 6. Finding a legal balance. So, how exactly do we synthesize all of this? How on earth does an employer survive this catch-22 while protecting civil rights and keeping the workplace safe? Well, the answer lies in what are famously known as the green factors. The courts and the EEOC basically tell employers, ditch the blanket no-felon policies. Instead, use this specific 3-step individualized assessment to link the specific crime directly to the specific job. For example, if someone has a 20-year-old conviction for a minor offense and they're applying for a landscaping job out in the open, the employer should recognize the incredibly low risk. But if someone has a recent conviction for embezzlement and is applying to be a senior accountant, well, the risk there is highly relevant. It is entirely about context. By sticking to these best practices, businesses can actually navigate this tightrope. It secures a safe harbor from negligence while treating applicants fairly without triggering that disparate impact liability. Treat every single applicant as an individual. Delay those criminal history questions so you don't screen out great people prematurely. And most importantly, have a real dialogue. Give them a chance to show if they've truly rehabilitated through education, training, or just the passage of time. I want to leave you with this final, truly provocative thought. As a society, how do we balance the deep moral need for second chances against the absolute, uncompromising demand for public safety? When has someone truly paid their debt, and how much risk should a business have to absorb to prove it? The tension between forgiving the past and protecting the future is for sure one of the most fascinating legal and moral challenges we face today.